Today we're going to be talking about build-out provisions and tenant improvements in leases. Our office is primarily a litigation firm, and so most times what we see are when things go wrong. We're always happy to help revise and customize and leases, but unfortunately, most times when people come to us, it's because they haven't done that on the front end. So start off with a little fun legal stuff or disclaimer here. It's up on the screen there, but this isn't intended to be any sort of attorney-client relationship by having this webinar. And what I'm giving you is not legal advice, but it's instead just for informational purposes. All right, now that fun stuff's out of the way. Again, my name's Simon Offord. As most of you probably know, I'm an attorney here in Palo Alto. We are a real estate firm. We do litigation and transactional work. I am one of the people in the office that does most of the commercial leasing issues, and hence I'm here with you this morning. And again, thank you all for being here. Hopefully the shine of the Warriors' victory is not going to overcome your ability to pay attention and learn something this morning. So first, provisions. I think we all know what build-out provisions are, but if you have some people that are less familiar with the issue, build-out provisions and tenant improvements are really striving to balance the needs of both the tenant and the landlord in order to modify the space for the tenant's needs. Obviously, in this situation, we have a balancing act of competing interests. The landlord and the tenant have very different perspectives and interests that they care about in these build-out provisions. The build-out provisions can be one of the biggest driving factors behind the negotiation of leases and the ability of one tenant to occupy a space. And so right up front, you got to have this stuff planned. So again, what we have is a balancing act. Some of the things that the landlord are going to be interested in are what's listed here on the slides. Control of the process. This is the landlord's property. This is, in some instances, maybe the only commercial property a landlord owns. And so they have a lot of interest in making sure that the property is well taken care of. A lot of landlords like to, for instance, dictate who the architect is going to be. They have an architect that they've used in the past for other parts of the building, and they want to continue with the same architect to keep consistency. So that might not be what the tenant wants, but it's very critical that there is control over the process for the landlord in many instances. Costs are obviously another big component. The landlord is going to be looking at whether he or she or it can afford to pay for the tenant improvements or wants to pay for the tenant improvements and recoup that money over the term of the lease, or whether it's a situation where the tenant is going to be responsible for the full cost of the build out. And again, this is very dependent on the situation and what the particular landlord is able or not able to do. And then third is the timing issue and rent commencement. This is one that oftentimes ends up in disputes if it's not dealt with well in the lease. So when does the rent commencement begin? Is it based on some defined term in the lease like substantial completion? Is it a set date that is sometime out in the future where you estimate that the work will be done? The rent commencement is critical because that's what the landlord's really looking for, is to start getting that check every month. So the landlord is going to be very interested in negotiating a rent commencement date that is favorable for him or her. The tenant's interests are going to be named. Tenants are also looking at very similar issues such as control. The tenant is going to be the one that is living or using, not living in the space, we're talking commercial leases here, of course, but using the space. The tenant has clients and customers coming in. They want the property to look nice. The tenant has very specific requirements of the kind of materials they're going to want, especially if it's some sort of retail store or restaurant. This is very critical to the tenant and running their business. Next is, it goes in line with what the landlord's interest is, of course, cost. Can the tenant pay to do the improvements themselves? If they can't, they're going to have to pay over time by having the landlord either give them an allowance or have the landlord do a turnkey improvement. And then finally, the risks that the tenant faces. If the tenant is putting the faith in the landlord to do a turnkey or do the improvements, we have to ask ourselves as tenants, as representative tenants, is the cost that the landlord is going to be claiming it's going to be actually pan out to what the estimate is? So what I mean by that is, if the landlord is charging a certain rate, essentially, or negotiating what he thinks the cost will be, can he do it cheaper? And then is that going to impact what the tenant decided to pay on a monthly basis? If the tenant is paying a lot per month because he thinks the improvements will cost $50,000 to $75,000, and then the landlord's able to do them for $25K, that's not a very good situation for the tenant. So again, competing interests, and depending on what side of the party you're representing or which side you actually are, you got to look at these kinds of things right up front. Okay, common terms. We'll go through this real quickly. I think we all know what tenant improvement are, TIs. That's why we're today. Build out provisions. This is sometimes built out or build out provisions is a term commonly used to deal with these issues. And the next two are the ones where we see the big dispute: rent commencement and substantial completion. Some people will argue that substantial completion is an easily defined term. I don't agree. I think you have to have a very specific understanding of substantial completion as part of your lease. If it's not in there, this is where we get a dispute. Same goes for rent commencement. The rent commencement issue is a very, very commonly litigated or contentious issue. So you want to make sure that that term is clearly defined right up front. And I want to also mention to everyone, we do have an option to send in chat questions down on the bottom left corner of the screen. If you have a question, feel free to send it in. I'll do my best to answer it. We're going to try to keep you guys not here too long this morning. I know that the attention spans can go quickly, so I'm going to be going fairly quickly through these slides. There's a lot of material, but please feel free to ask questions when they come up, and I'll do my best to get them in. All right. What we have on the screen now is a sample, and this isn't intended to be what you should be using as a build-out provision. And the reason why is because there isn't a good boilerplate for a build-out provision. What you have in front of you is what is essentially in the AIR commercial lease as to condition that the premises are supposed to be delivered in. This is about as simplistic as it can be. The landlord's going to deliver the unit room clean and free of debris. Okay, that rarely is ever going to be sufficient. And so I can't sit here and tell you I've got a great boilerplate example of a tenant improvement allowance or of a build-out provision, because every situation really is different. There are so many factors that we're going to get into later that are going to alter how these provisions need to be crafted. So is there a sample for this? Unfortunately not. Unless you've got a place that's move-in ready that doesn't need any improvements, this kind of language won't do. So the big key here is, and we'll get into more specifics on this later, is if there's substantial improvements, I like to see an actual work letter as attached as an addendum to the lease. The work letter needs to be very, very specific in detail, and we'll talk about that in a few minutes here. And you'll see a couple of those Simon says throughout the presentation. Again, I apologize, but we got to keep it interesting somehow, and so hopefully you enjoy some of those kind of things we've got. I was fortunate enough to have my parents name me Simon, so I've been getting that my whole life. Okay, so how does this process start? I think we all know how it starts. It starts with the LOI, the letter of intent. It's critical that if you're a tenant or if you're a landlord, to have a sense of what you're going to be doing and what you need to know before you even get to the letter of intent stage. So what does that require? It requires coordination, and it requires you having your contractors lined up, your architects involved, and everything all set up and ready to go before you even get to the letter of intent stage. It's critical for both sides that when that letter of intent comes in, you know exactly what you're looking for. You know what your costs are going to be. You know what kind of improvements need to be done. This is especially true when it's the tenant that's sending the initial letter of intent. The letter of intent needs to build out issues, obviously. It's a key negotiating point in any lease, and you can't get anywhere unless you have those build-out provisions pretty clearly stated in the letter of intent, and they've got to be detailed. You've got to understand that the letter of intent is just the first stage to getting to a lease. And last thing you want is to have some ambiguous letter of intent that leaves open issues later that's going to prevent you from actually getting into contract, because what you've got in there isn't clear. So be as clear as possible up front and get as much work into the letter of intent as you can with specifics about the improvements. Again, we're going to talk about those specifics in a few minutes here because that's probably the most important part of the presentation. Again, Simon says, just like I said, put as much information as possible in your letter of intent. It's critical to get it out there up front, have your contractors on board, and know what you're going to be doing. All right, structuring build-outs. Here on the slide, we have our play. This is the critical part, knowing what you're doing in advance, getting those plays set, setting those screens for Steph Curry to make his threes like he did all days long. First issue that you need to consider is the cost sharing. Okay, we have a spectrum of ways this can work, right? We have 100% of the landlord providing a turnkey situation. And so if the landlord is going to be doing 100% of the cost sharing, obviously there's going to be some expectation that the landlord is going to recoup those costs throughout the term of the lease in the way of an increased rent. Somewhere in the middle, you can do a situation where you have an allotment provided by the landlord, where the landlord is going to offer a certain set sum for which the tenant can use to do the improvements, and then anything in excess of that sum, the tenant can then choose to pay on his own and get the funds himself or herself to do that. And last, of course, is where the tenant's going to pay for everything. It's somewhat rare that this happens because tenants don't often have the sufficient capital to do all the improvements themselves. I most commonly see this in franchisor or franchisee situations, or situations where you have a long-term business moving into a new space. Again, so in those situations, it's completely dependent on financial abilities of the tenant, whether they're going to be willing to pay all the money up front or they need some help from the landlord. And obviously, this is critical in the negotiation of the letter of intent phase and figuring out what you can or can't do. All right, and again, Simon says, obvious, but you'd be surprised how many people don't make this clear. Have in the lease exactly what the party's responsibility is going to be, what's going to happen with cost overruns, who's going to pay for what. It all needs to be crystal clear in the lease, otherwise that's where we get to the disputes. Again, we're going to get to the nitty-gritty in a few minutes. This is kind of a big picture oversight right now. The other big issue that we see is rent commencement. The rent commencement is probably the most critical issue to the tenant and also to the landlords, frankly. Tenants don't want to pay rent, landlords want to get the rent. So when does the rent commencement begin? This is where I have people come in more than any other time, because you get somewhere through the project and the landlord's saying, okay, we had a date set to start the rent. Tenant, where's my rent? And the tenant saying, well, you haven't done what you said you were going to do. Or there's a set date and the date's gone by and the landlord isn't done. The tenant's supposed to be doing the improvements, they don't finish them in time, or they've taken forever to finish them. Then when does the rent start? Again, this is completely dependent on what kind of system you're setting up. Are you doing turnkey? Are you doing an allotment? Are you having the tenant pay for everything and do everything? But whatever way you go, you need to be clear when the rent is going to commence. Within this issue is this idea of substantial compliance or substantial completion. Rent begins when substantial completion of the project has occurred. Well, what does that mean? Some people will argue that substantial completion is a clearly defined term. I disagree. I've defined a number of ways in leases, ranging from just saying substantial completion is when rent commences and leaving it at that. That's never going to be good enough, because who knows what that means. You have to actually define it. And then there's a range of ways people define it. Is it based on when the certificate of occupancy is issued? You see that a lot in leases that are for office space. Once you can occupy the unit, then the rent should commence. That's a fairly easy spectrum and a fairly easy guideline as to when the rent will commence. So if you're using a space that will need a certificate of occupancy and it's an office space or something, that might be good enough. Other times you see such things as when the scope of the work as agreed to by the tenant is substantially complete. Okay, well that still leaves some question as to what does substantially complete mean. Does it mean that all the work is done and you still just have a punch list of items to do? Is it once the punch list is actually completed? Is it a few days before everything's done and the tenant's allowed to get in there to put in their fixtures? So for instance, if it's a restaurant and the landlord has agreed to put in most of the improvements, but for the refrigerators, stoves, and any other special things that the tenant will be purchasing, is it once everything is in, including the tenant's improvements, or is it once the landlord's delivered the unit so the tenant can put in their trade fixtures? Have it in the lease. If you don't have it in the lease, that's where you may get in a fight. You can imagine from a landlord's perspective, they get everything done, they get the shell complete, the wiring done, the painting done, the floors in, the counters in, and they say, okay, rent starts now, and then the tenant says, well, I've ordered my range and my stove and my walk-in fridge, but they're not going to be here for a month. So once we get those, then we'll start paying the rent. Okay, there we've got a dispute. It's a month's worth of rent that could be significant for both sides, and then either the landlord's losing money or the tenant's paying money when they're not making an income. Evidence, make sure it's crystal clear. Again, Simon says, I think rent commencement is probably the most contentious issue as I see it, at least as far as understanding the terms of the lease and build-out provisions. Certainly there are other bigger issues that can come up in leases, but for this specific issue, what we're talking about today, build-out provisions, rent commencement is probably the biggest one. Okay, so how do we deal with rent commencement? One other thing that you can do is include very specific deadlines, phases, information in the lease that gives both parties a clear understanding of what the dates are that certain things are supposed to be done and what those dates trigger or indicate. So you can have benchmarks in there, milestones for completions of phases of the project. Say the shell work will be done, the HVAC will be installed, the flooring will be done, counters installed, all that kind of stuff. If you have clear benchmarks, then that can kind of help everyone understand their responsibilities and more importantly, frankly, keep everything on track. It gives either the landlord or the tenant, whoever's doing the improvements, some motivation and some sense of when they're supposed to be getting things done, and it makes it more real than just saying when everything's done you can move in and start the rent, or everything will be done by March 1, 2016. Well, if it's a massive project, we know with construction it oftentimes can get delayed, so if you have benchmarks in there, it helps keep everyone kind of on top of things. And then the other thing that comes up is delay. So you want to have really provisions about how to deal with delay. Delay can come just because of things like the force majeure, the act of God, weather, earthquakes, stuff like that can cause delay where it's nobody's responsibility. So what you have to do is make sure that the lease addresses that. What happens if there's a delay because of something beyond either party's control? Who's going to pay for that? What about change orders or change plans? The tenant starts into the project, he or she realizes they want to do something different, and the landlord is actually the one that's supposed to be providing a turnkey. Who pays for the additional time it's going to take to make those improvements? Well, the landlord's obviously going to want to require the tenant to pay for that extra delay. So the tenant either will pay a daily rate, or his or her rent will commence earlier or on time, despite the fact that the work might take longer. Again, if that's not in the lease, though, that's where we get into disputes. So you've got to identify these issues early and have them in here. Just as a general point about this presentation, we don't have time to get into the specifics of every way that these things can come up in every single scenario. So what I'm trying to do for you today is give you a broad perspective, an issue spotting kind of approach to where you understand all the things that can pop up. So you look for those in the lease, so you don't forget to include those in the lease. The key thing is that understanding all the areas of dispute so you can prevent them later on, and that's what my goal is here today. All right. Next, again, substantial completion. How is it defined? Who determines? We spoke about this a few minutes ago, but this is a hot button issue. I get the feeling that there's just kind of a common perception that it's understood what substantial completion means, and I just don't agree with that. It's like the common perception that LeBron James is the best basketball player in the world because of X, Y, and Z. Well, you're going to get disagreement on that. He lost last night, so maybe he's not the best. I don't know. But you got to define these things up front. Otherwise, people by their nature like to disagree on things, especially when money's on the line. So make sure it's defined. I can't tell you how many times I've seen it where it just says rent commences upon substantial completion. What does that mean? I've got tenants and landlords coming knocking on our doors saying, hey, what does that mean? I can't tell you, unfortunately. It's got to be defined in the lease. Go back to that slide real quick. The other issue on that is who determines substantial completion. Is this a collaborative thing where the landlord and the tenant have to agree, or does just one side get to dictate what substantial completion is? Again, this really helps if you have specific guidelines for it, such as when the certificate of occupancy is provided, when the final permit approval is given by the city or the county. Stuff like that makes it a lot easier than just saying when the work is done. Okay, details of the project. Now this is where we're getting to the important stuff. Once you've worked out all the financial aspects of it, who's going to pay, when the work is going to be done, this is the other big dispute area: is how is the work going to be done? The landlord has a certain expectation, and the landlord has a certain concern, which is cost and timing. The tenant has obviously certain considerations, which is the quality, the materials, timing as well, layout specifications, and all that. So this is where it helps to have a contractor on board right from the get-go, someone you know and trust, and also someone advising you give a second read-through of the work letter. When I talk about details on the project, what I'm talking about is that work letter that's going to get attached to the lease. If you have an empty shell building and you need to convert that into a restaurant or an office space, it's going to be a very complicated thing. I unfortunately see people come in my office all the time with leases that say, landlord will provide a vanilla or gray shell, and a bathroom and cubicles. Okay, what does that mean? Does that mean he's going to provide a bathroom that you'd find down at a construction site somewhere, or is he going to give you the bathroom that you're going to find over at Hearst Castle that's a grand, perfect bathroom? Obviously, the tenant has expectations and the landlord has expectations. If you don't have details, that's where we start to butt heads. So the best work letters I see are things that are literally just straight from what the contractor is going to give you for the scope of the work. It's going to go through step by step. Bathroom, these are going to be the specifications. We're going to use X type of countertops. We're going to use this kind of sink. We're going to use this toilet. Sometimes if you don't know exactly what your design is going to be, if you don't have your designer or your architect lined up, you might be able to get away with doing it. The counter is going to be at a minimum cost of X. The floors are going to be at a minimum cost of X per square foot. That's better than nothing. I prefer if you have more specificity, though. Prices change. People's opinions change. What the landlord wants to do, what materials, products are available changes. So if the tenant wants a specific kind of flooring, but it's going to cost 3 extra weeks to get it, or the landlord has to pay some sort of expedite fee, well, how do you deal with that? If you have a price per square foot only in there, the landlord can probably argue and will probably be able to prevail and say, well, we can't get this one, so this one's the same price and it's good enough. Well, if you're the tenant, that might not be good for you. It might not be what you want. And then again, you're in a fight where maybe the tenant is then going to have to incur an extra cost to pay for the delay or to pay for the expedite fee. So the more specificity, the less likely you are to have those disputes. I know work letters can be tedious and long, but in my opinion, you can't do this without having one attached. and every detail down to the line as best if possible. I know there's the time constraints and the concern that you spend all this time doing a work letter and then the negotiations fall through, but I'd rather see it done right up front than have these issues come up later. Of course, the problem is that issues come up later and you get in a dispute, then you as a landlord aren't getting paid rent because you and the tenant are fighting, and you as a tenant aren't able to start your business and make money because you're in a fight and you're going to mediation or arbitration to decide what the landlord or what the tenant's requirements are. And the details of the project is especially critical when there's a turnkey, when the landlord is doing the project, because if the tenant's doing the project, they're in control of everything. So as long as the landlord's approved it and there's no requirement for the tenant to, or excuse me, the landlord to do or not do something, then it's not as big of a deal. But you still want to have some understanding and approval by the landlord of the plans, even if the tenant's going to be the one actually executing the improvements. All right, Simon says, here we go, avoid shell language or ambiguities about the project. Like I mentioned before, I see people just put in leases that the landlord will provide a gray shell or a vanilla shell. There's a very wide range of understandings as to what a shell means. So this is critical to actually define. If you're going to use vanilla shell, that's okay, as long as you have a paragraph or more, what we're talking about, essentially a work letter saying exactly what that shell will include. Will it include HVAC? Will it include taped walls? Will it just be the studs? Will there not be studs at all? All that stuff. Saying gray shell to me means something different than it does to you, than it does to the contractor. So ambiguous language like that doesn't cut it. That's where we get the disputes. Simon says, number 2 in this slide, involve your contractors early in the process. I've said it once and I'll say it again. You got to understand what the costs are going to be, how long it's going to take, what specifics you need, what the permitting issues are going to be, and most of us don't know this stuff unless we have an expert, a contractor, in to help us. Last, Simon says, this one will be repeated throughout, include the work letter as part of the lease. If it's not in there, that's where we get into a fight. Okay, next issue are approval rights. This works both ways. Landlords are going to want approval rights if the tenant is doing the improvements. So the landlords are going to want to have some control over who the contractors are. Is it someone that they know or that they know is going to do good work? After all, this is the landlord's property. He or she doesn't want some cut rate contractor in there doing damage to the property or risking damage to other units, stuff like that. So the landlord should try to get some sort of approval rights of the contractors, making sure they're licensed and bonded and have sufficient capital to finish the project and all that. Plans. The landlord should probably want to have some approval rights over the plans. Again, making sure that the structure or the build out isn't going to impact other tenants or the landlord's long-term ownership and use of the property. And finally, a review and comment stage. Give the landlord an opportunity to propose changes and comment on the plans or improvements themselves. Landlords are going to want to negotiate these type of things into the agreement. Next, we have tenants. Same kind of things. If the landlord is doing the improvements, the tenants are going to want to be able to approve and review the plans and have them be part of the lease. Again, the tenants are going to want to have some control over the contractors. It's got to be someone the tenant's comfortable with because they're going to have to work with these people. And then finally, final approval of the project. This is a big one because the landlord might say the project's done and it has all kinds of issues, and if the tenant hasn't had an opportunity to have some sort of final approval and to prepare a punch list or provide changes, then we're in trouble. The tenant is going to want to have that right before they can say, okay, we're up and running and the lease is ready to go and the rent's ready to start. So from the tenant perspective, that's something you want to have in there. All right. Again, Simon says what I just said. Tenants, you want to have that approval provision. This is a key one. Again, if anyone has any questions, please feel free to send them in the chat. We're getting about 3/4 of the way, almost done here. So if you have questions, please put them in the chat, and I'll try my best to answer them. All right. Another big issue is escape provisions. Sometimes when landlord or the tenant, more likely, is getting involved in negotiation of the lease, they might not understand the full scope of the costs. This is especially true if you have a really big project. If you're moving into a warehouse and you have a big box store or something like that, you get in there and you realize there's significant issues, and the improvements are going to, what you thought be $100,000 turn out to be $200,000, $500,000, et cetera. So tenants like to have these kind of escape provisions if they're the ones that are actually doing the improvements. These can arise, like I said, unexpected improvement costs, compliance issues, if you can't get the permits, if you can't get a certificate of occupancy, if there's some restriction from the city on the type of business, all those kind of things. Tenants going to want those for compliance issues. Permitting, exactly the same as the compliance issues. And then last is hazardous waste and toxic materials. Is there some asbestos remediation that needs to be done? Is there some sort of underground tanks that need to be removed? Those kind of things need to be dealt with. One more thing on the compliance issues is the ADA requirements. Tenants might have to be responsible by the terms of the lease to bring the property up to the ADA code. What happens if they think that that's a small project and it actually turns out to be a lot more expensive? Is the landlord going to allow a provision to get the tenant out if that happens? So on the next slide here, we have an example of this. This particular example deals with improvement cost contingencies. So in this situation, we have a tenant that's going to be doing all the improvements. And, they have an expectation of what the cost is going to be, but what happens if it exceeds that cost? So let's say the cost is $200,000. They get in there, they realize, wow, we have to do X, Y, and Z that we didn't realize. The structural components need to be beefed up. There's a roof issue, something like that, that's negotiated into the lease as the tenant's responsibility. Well, what if that happens? Are you as the landlord going to let them get out? This is one where the parties agreed that if the cost exceeded the agreed upon sum, the tenant could get out of the lease, but they still had to pay the rent for an agreed upon time. In this situation, you see it's 6 months. So that still gives the landlord some assurance that they're going to have some income stream for at least a little bit while they go out and try to find a new tenant. But it gives the tenant an opportunity to get out if it just becomes financially impractical. Again, this can be a big negotiating point, especially when you have a larger project. So whatever side you're on, think about this and whether you want to allow that. This could be a difference maker in getting a lease done. All right, shot clock here. Before the improvements are done, getting things done in time, getting them in within the 24 seconds the MDA allows. What do we got here? All right, so these are the kinds of issues that can come up before the work is done, while we're still in the ticking shot clock. Work's not completed in time. What do you do, and does your lease provide what to do when the work's not completed in time? It's critical to have that in there. So are there delay in rent provisions? Who's responsible for the extra cost if it takes longer? All those kinds of things need to be identified in lease. Permitting issues. Again, who pays for the overrun if there's issues with getting the permits in time? Agreed upon costs. What happens if the landlord has agreed to do the turnkey improvements, but the tenant then wants all these changes? Who's going to pay for those? Again, you got to work all this stuff into the lease, because you don't want to be in a dispute sometime after the lease is signed, fighting about who's going to pay for them and how you're going to get these things done. Otherwise, the landlord's rent, the tenant's losing time. After the improvements are done, these are the technical fouls. These are where we get into disputes. Poor quality and workmanship. Again, if it's not worked into the lease, the quality, who the contractors are going to be, then you can get into a dispute. This one's sometimes one, though, that can't be controlled. You have a landlord that tries to cut costs and do a bad job, and the tenant's not happy. How do you resolve that? That's a tough one to actually deal with in the lease. So this is an area of dispute where you sometimes see come up later on. latent defects. The tenant moves in, everything seems fine, but then once they get in there, they start realizing that corners were cut and there were issues in the work. How is that dealt with in the lease? Failure to pay contractors. Tenants taking on the liability, or excuse me, the responsibility to pay for the improvements. What happens when he doesn't pay the contractors and the tenant and the landlord gets a mechanics lien stuck on the property? Well, there better be language in the lease that says that the tenant's going to indemnify the landlord for anything like that. So is that dealt with in your lease? One of the things you got to make sure is in there as a landlord. And of course, now that we have these disputes, what happens? Breach of the lease. Most leases nowadays, especially the standard form leases, do include a mandatory mediation provision, meaning you can't sue the other party until you've actually tried to participate and resolve the case through mediation. A lot of the standard form leases also now have an opt-in to agree to an arbitration. That's a checkbox sometimes, or it's a separate form that can be attached. Whether or not arbitration is right for you is a conversation for another day. What happens about the loss of rent during the litigation? Who's responsible to pay rent when the improvements aren't done in time? Big area of dispute. And lastly, a lot of our leases now are seeing attorney's fees provision. So keep in mind that if you get into a dispute and you lose, you could be on the hook for attorney's fees if that's in the contract. So there's things to look out for when you get into a dispute and how to deal with them. Now, how can we help you? How can we get a slam dunk for you? Well, there's two ways we can help. Obviously, the better way is before the process. Let's try to get that lease tied down. We'll set a screen for you, so to speak, to make sure that the lease is clear and that you're free of any issues to the best we can. We obviously can't anticipate everything, but we see the disputes, so we know how to avoid them. Filling in gaps, if there's missing holes, some of the issues we're talking about today aren't addressed, let's get those in there. And just generally protecting and advancing your interests. Sometimes tenants don't realize or landlords don't realize what points in the lease are and what the negative impact can be, so we can at least advise you on the risks so that you know moving forward whether you want to try to negotiate those out or if you're okay living with those risks. And then, of course, after the process, this is where the litigation and dispute resolution comes in. We can help negotiate resolutions for you, give you collaborative solutions, try to come up with creative ways to get everyone happy, or if not, protecting and advancing your rights, filing suit, going to arbitration, going to mediation, whatever it takes to get the landlord his rent or the tenant moved in, and hopefully not break up the relationship, because that's a loss for everyone. You've committed a lot at this point. Let's try to get you into the property. All right, overtime. We are a little bit over time here, and so that's why we have this slide. These are some issues that are relevant to this fact that we just don't have time to get in today. Franchisee, franchisor issues, how those are dictated in a lease. Franchisors oftentimes have very specific requirements, so how you can deal with those and work with the franchisors. Change orders, how change orders are dealt with. We spoke about this a little bit, but the contractor rules and contractors licensing, mechanics liens, these three issues are all conversation for a whole nother day. We talk hours about contractor issues like that. And then we spoke about it a little bit as well, but ADA and hazardous materials compliance issues, how to deal with those, what are the risks in those, and how you can try to avoid and benefit yourself by working those provisions in your favor. Okay, final thoughts. These are my list of Simon Says. Again, I've said it multiple times. Include that work letter in the lease. Be detailed in everything, especially the LOI and the work letter. Have those cost responsibilities clearly laid out. Be clear about the rent's commencement details. Don't just say the rent's going to commence on some undefined term. Either put a date in or put in some really clear definition of what substantial completion is, or it commences upon certificate of occupancy, something clear and definable, not something ambiguous. Avoid shell language, be more specific than that. Involve contracts early in the process. Again, you need those experts to help you in your negotiating power and just understanding what you're getting into. Add approval provisions. This works both ways, as we discussed. And have an attorney review your lease. You never know what kind of things can pop up, and we've seen it all, so we can help you try to avoid those issues. All right, I want to thank everyone for joining me today. 45 minutes, not too bad, hopefully, for you. Hopefully you learned something, and again, that you're enjoying this morning after the Warriors' big win last night. I don't see any questions right now, but if you do have questions, please feel free to send them over to me. I think we'll also have these slides available in some sort of downloadable form. And there will be a link for the replay. I see a question about that. Absolutely. We're going to have this on our website somehow. We're happy to send you that link if need be, and you can access it any time, as well as the slides. If you have any questions, also, please feel free to email me. My contact information is here on the slides, and thank you guys again.